everyone. Welcome to The Presumption. I'm Sara Azari with Jim Griffin, my co-host, and Matt Fondelier. And we are joined by a very special guest, Peter Eliasberg. Welcome, Peter.
Hey, Sarah. Thanks for having me in.
Of course. And so today we're talking about a very, very important issue, jails in America. And Peter is the chief counsel and Mannheim family attorney for First Amendment rights for the ACLU here in Southern California. Of course, the ACLU does great work across the nation. And I'm going to talk to you a little bit about Peter's. He's just really humble, but he's a guru, and I relied on him through the pandemic when I was dealing with COVID horrors in BOP facilities. And I've known of him through a lot of mutual colleagues. So I'm really thrilled that you were able to join us. Peter graduated from Harvard Law School, magna cum laude. I love that. I always like to say that because I made it to cum laude, but it really means wicked smart. And in Latin, it means with honor, with distinction. And he went on to clerk for Judge Sporkin of the D.C. District Court and later Judge Reinhardt of the Ninth Circuit Court of Appeals. He joined the ACLU in 1996, serving as managing attorney and Mannheim family attorney for First Amendment rights, later becoming a legal director. From 2016 to now, he's been chief counsel at the ACLU Southern California, and he's worked on significant cases from prisoners' rights to First Amendment speech and religion, Fourth Amendment and privacy, disability rights, educational equity, equal protection, to freedom of information and habeas corpus. And, you know, you truly do God's work among those of us who litigate. And most recently, you led the litigation called Rosas versus Baca. Sheriff Baca was our old sheriff here in LA County. And this was a class action lawsuit in federal district court challenging a pattern of deputy on inmate abuse in LA County jails. And so even though your work obviously is here locally, it really, I mean, this is a problem across the nation. And so I do want to talk a lot about this particular case, but, you know, I think Jim has gone after jails where he is, and we see the problem everywhere. Lots to talk about, but fundamentally, it all comes down to civil liberties. And so America is supposedly defined by the protection of people's civil liberties. And yet in our jail system, which houses some of the most vulnerable populations like drug addicts, the mentally ill, you know, cognitively challenged, the poor, and where the government is quite literally running the day-to-day lives of these people and the meal-to-meal lives of these people, we're seeing the most inhumane and neglectful conditions. So my first question is, for the viewers who may not know, what is the ACLU and what is its involvement with jails nationally and locally?
So the ACLU is a national organization that has affiliates in every state. Our mission is to protect civil rights and civil liberties that are protected by federal constitution, state constitution, and a variety of different statutes. A lot of employment discrimination law, for example, is statutory rather than constitutional. We have a large office. The Southern California affiliate is one of the largest in the nation, not the largest, but one of the largest. Our national office, we oftentimes coordinate with our national office. Our national office has what's called a National Prison Project that does work in jails and prisons around the country, but does not have the resources, the ability to deal with the enormous problems in jails and prisons everywhere. So sometimes or oftentimes affiliates in different jurisdictions do that work on their own. But in some of the larger cases, and the LA County jails is the largest jail in the country and has all sorts of awful problems. So we work very cooperatively with and co-counsel with our National Prison Project. So really all of our jails cases are kind of they're team efforts between the Southern California affiliate or at least our jails cases are team efforts between the Southern California affiliate and our National Prison Project.
Mm-hmm. This case, this recent litigation and the settlement that occurred in June involved the IRC at Twin Towers. Jim, we have a few men's jails in LA County. So we have Wayside, which is up by Magic Mountain. And then we have Twin Towers South and North, and we have Men's Central Jail. And then at Twin Towers, there's an inmate reception center, what we call IRC. I don't know if you guys have something similar in where you are, but it's where inmates that are just booked, these are people detained pre-trial, they go through essentially being processed, physical, checkup or mental, whatever, and then they get housed from there. And so, Peter, what is the history of federal oversight of the LA County jail system, and what drew ACLU's attention to the IRC, which became the crux of your case?
Well, Sarah, the sad thing is that oftentimes the civil rights litigation involving jails and prisons is sometimes the hardest. They're the hardest cases to do. They're the hardest cases to, you oftentimes can win a judgment in a case or get a good settlement, but then actually having that implementation and come to full fruition and get the results that you want to get is very difficult. And there are all sorts of reasons we may want to talk about and we may not, but the Prison Litigation Reform Act, I think judges' reluctance to, quote, micromanage jails and prisons, even when the conditions in them are absolutely abhorrent and clearly unconstitutional, they all pose real problems. And the reality is that civil reform litigation generally requires buy-in. Yes, there can be a court, there can be plaintiff's counsel you're trying to enforce, but oftentimes unless you have some buy-in from the entity itself, whether it's the state prison system or usually, at least in California, the jails are run by the sheriff's departments, unless you sort of have internal buy-in, it is extremely hard to get the kind of change that needs to happen. So the sad reality is the case that you're referring to, our Inmate Reception Center, that is part of litigation that we've been doing since the Ford administration, that's involved the oversight of the county jails, because the county jails have never really come into compliance with their legal obligations in providing decent, safe, humane treatment of the people who are there. But our focus recently has been the Inmate Reception Center, because that is where some of the worst problems kind of piled up. And the Inmate Reception Center is not a housing unit. It is a processing center. But what was happening was there were so many people going in and the processing, and then there were so many problems within the system. So perhaps the greatest one was they didn't have enough specialized housing for people with mental illness. And a tremendous number of people coming into the system have mental illness. So someone would come in, they would identify that person as having serious mental illness. The only safe place to put them would be in what they call specialized mental health housing, and they didn't have the specialized mental health housing available. So what was happening was the Inmate Reception Center was becoming, in effect, a housing unit. Not in any real sense, people sleeping on cold concrete floors for 24 and 48 hours, all sorts of other problems. But they were, in effect, the reception center was becoming a housing unit, even though it shouldn't be. And so we jumped in on this because the conditions were so abhorrent. You just saw one example of a photograph of people sleeping without any kind of bedding, without blankets, without mattresses on the floor, because they were there for 24 and 48 hours and sometimes even longer. So we went in, and over the course of a process of about 9 months, we moved for a temporary restraining order, then we got a preliminary injunction, and eventually through negotiations have entered into a negotiated permanent injunction with the county that provides that nobody can stay in the Inmate Reception Center for more than 24 hours, that people with mental illness cannot be. They were doing this absolutely inhumane thing where they were chaining people with mental illness there was a reason for it. They said, we're really worried that these people are very sick and potentially may try to kill themselves. So how are we going to prevent that from happening? We're going to chain them to a bench. And sometimes that chaining to a bench would be for days at a time. Well, that's a horrible thing to do to anybody, but somebody with serious mental illness. So they've had to take a whole bunch of different steps. They're now barred from chaining anyone to the front bench for more than 4 hours. They're having to figure out ways to process people. But ultimately, the solution to this problem is stop putting so many people with mental illness in the jail. It's a disastrous system that exists around the country. People with mental illness, whatever you believe about the deterrent value of incarceration, and I have serious doubts for many people, but people with serious mental illness are not learning a lesson. Oh gosh, gee, I did something bad and you've taken away my liberty and therefore I shouldn't do that again in the future. That's not what's happening with people with serious mental illness. They're decompensating. They're getting sicker and sicker. They're removed from the kind of supports in the community that may, help them heal, may help them get better, may keep them in a situation where they can live a humane life. So incarceration is a complete failure for people with mental illness. And as long as we keep making our jail systems and our prison systems also, but our jail systems particularly sort of the de facto mental health treatment, even though they don't really get treatment that's worth anything, the de facto mental health treatment facilities for the people who don't have insurance and don't have money, we're going to have this cycle of disaster over and over and over again. So what's heartening about the resolution that we reached in the IRC is not just that they have to provide certain things for people in the IRC, can't keep them in there for too long, can't chain them to bench for too long, but in fact, they're committing to building beds in the community for people so that people with mental illness can get diverted and not get put into the jail system, which is a disastrous place for them.
So I'm going to push back on that. When I talk about this, I talk about, the stigma around mentally ill people and how there's a myth that they're violent offenders or just, statistically, they're actually more vulnerable. They're more victims of crime than perpetrators of crime. But, you hear people say, well, but, they are where they belong because they're dangerous. You're going to divert them and then they're going to be on the streets and that's why crime is up. So what is the response to that?
Well, diversion shouldn't be to the street. And that's not what true diversion is. But I think in a weird way, there are all sorts of horrible problems in Los Angeles. But to the credit of the Board of Supervisors, they actually created an agency under a lot of political pressure called the Office of Diversion and Reentry. The Office of Diversion and Reentry's goal is to either prevent people with serious mental illness from going into the jail or trying to get them out of the jail as soon as possible and into appropriate community treatment. LA is in some ways a laboratory. The recidivism rates for people with mental illness who go through the jail system, they're horrific, like 90% recidivism, even if by and large the crimes and charges are not violent crimes. The people who go into these ODR programs where they get housing, where they get mental health treatment and a variety of other services they need, the recidivism rates are infinitesimal compared to the recidivism rates for people who go through the jail system. So even for somebody who says, I don't really care about the humanity, all I'm interested in reducing crime, the answer is this: diversion into programs where people get treatment and housing is far more effective in reducing crime than sending people with mental illness into the jail. Now, look, there are people with mental illness who do commit or were at least charged with very serious crimes. And I think there's a valuable debate about whether some of them maybe this kind of community treatment doesn't work or maybe threatens the community. But by and large, the success rate of the Office of Diversion and Reentry, their programs aren't large enough and we're not putting enough people through them. But it's just, there's not even a debate which one protects public safety better. It is very clear from the results of housing retention and future crimes committed or arrests made for people with mental illness who go through the ODR programs, it's way better than the ones who go through the jail system.
Peter, isn't the real issue funding? I mean, it's been my experience. I've done some jail litigation that the administrators are begging for more money and they sort of welcome a lawsuit because it helps them go and get more money to fund, their programs and the needs that they have. I mean, I don't know what experience you have out in LA, but here in the South, I mean, that's the least funded operations are the jails, particularly county jails. And
yeah, I mean, Jim, I think that's a great point. I have not litigated in the South. I've always worked at the ACLU of Southern California, but certainly talked to my National Prison Project colleagues who tell me horror stories about some of the jail and prison work that they do in the South. But it ain't good anywhere, honestly. It ain't good anywhere. But, stories I hear about Angola, that's a prison, but in Louisiana and so on, they turn your stomach and make your hair stand on end. But you are correct. This is, there is no question that there is a lack of resources. But I think what I'm trying to get at is it's not just a question of resources, but where those resources are directed. Mm-hmm. And what I would say is that not only are programs like the Office of Diversion and Reentry, these diversion programs for people with mental illness, they're more successful in terms of reducing crime, maintaining stable housing, and so on. They also cost less than it costs to incarcerate someone with mental illness. The costs of incarcerating somebody in a jail generally are very high. The costs of doing it and providing even very bad mental health treatment are astronomical compared to the costs associated with doing that in a community setting.
Right. And what across the country, if you know, are facilities run better when they're contracted out to private enterprises versus, public operations? Do you have any sense of that?
So I can't speak to it from my own empirical experience because there really is not much in the way of private prisons in California for complicated reasons. In large part, it's because the prison guards union is so strong out here that they've basically fought against this. But my sense is from doing reading and again, talking to my National Prison Project colleagues that the answer is no. It's not as if governments run jails and prisons well. But once you get a profit motive involved, what's basically involved is they try to figure out the ways to do this on the right. very cheapest way they can. And they cut costs on things like healthcare, medical care, mental health care, and other things. Oftentimes there's huge understaffing, which leads to increased chances of violence, et cetera, et cetera. So my sense is that private prisons are a disaster. And the idea that somehow or other we get the hand of the market. I mean, there may be some things that the market does well, but the market is geared towards having a profit motive. And if there's some services that you can't provide them, whether it's bus service or anything else, if what you're trying to do is do it on the cheapest way possible.
I agree.
You mentioned something about, you were talking about being handcuffed to the benches, and then I guess they were also caged for long periods of time, right?
Mm-hmm.
They were,
yes.
And then this is what just shocks the conscience, is that they were forced to defecate on the floor and in food containers. And that one of the inmates essentially said, this is not how you treat anybody. And I just thought, it's not even how you treat your animals, But you had mentioned, Peter, that this sort of dilemma has been going on since the 70s, I guess. But that after that preliminary injunction that Judge Pragerson issued, that the county failed to comply with that. And then right before a contempt hearing, I'm just going through the procedure, is when you guys settled. And the county is doing sort of the compliance assessment or whatever. How do you trust the county to do their own when they failed for so many years? I mean, how do you trust them to come back and say, okay, so we're good right now, or everything's fine?
Well, I mean, great point. And oftentimes another aspect of institutional reform litigation is, a key question is then how are you monitoring compliance? Yeah. Right. But it's not just, the county doesn't get to just say we're doing great. The county has, and under the pressure of this lawsuit, they created quite a good system where they're now tracking, and I'm not a tech guy, but, having like in a grocery checkout, you have those barcodes on people's wristbands. They are now tracking somebody who's booked into the jail from the instant they're there. They're able to, they now have these huge monitors in the inmate reception center with the name of everybody on there, and they can see, okay, the clock's running. They've been here for X hours, or they've been on the front bench. If they've been on the front bench, how many hours? And so they provide reports of that information to us. We also have a special access to the jail, so we'd go in and do some of our own individual checking. So it's not just a trust us, we're doing great system. It is a system that's backed by data, and then independently we can corroborate by going in and talking. Plus, there's signs all over the jails that make clear that they can call our hotline, and people make complaints, and we use those complaints also as a basis to assess what's going on. But no, any kind of monitoring system that's based on trust us, that's not going to work. But I think we've done a good job of building in a system. And look, obviously, this has been a nightmare and a long piece of litigation, and the county has been far from perfect. Mm-hmm. But they also have not been entirely obstructionist. They really did put in a very good under pressure of this lawsuit and under the threat of contempt, et cetera. So we can't minimize that. But that monitoring system that they put in place is really pretty impressive. I mean, it really does allow the tracking of people through the inmate reception center in a way that we can determine is that permanent injunction being complied with or not. And they've gotten much better. They've gotten way, way better, and we've been able to verify those improvements.
When the mentally ill person is being considered for diversion, because your message is the solution is decarceration, right? And so getting a lot of these mentally ill people out of there is going to help alleviate some of the burden and overcrowding. But is there criteria on, for example, a detainee that's there on a murder charge versus somebody that's there on a lesser charge? I mean, can anyone get diverted out, or is there criteria?
Well, there are a lot of different. There are certain state laws that govern what diversion is possible, and there are certain charges where diversion is not allowed. And I think that's going to be true. That's just going to be a political reality. But then there are also sort of diagnostic criteria. And the Office of Diversion and Reentry has really good clinicians who make assessments about, what is the condition, what is the right program to put somebody in, what stabilization may be necessary, because oftentimes people come into the jails in the worst possible condition. They may be homeless. It may have been compliant with taking certain medications that were helping us, but then now they're no longer compliant. So there are a variety of different things that have to be considered. But if it's done right, and I think ODR generally does it right, they make very good judgments. And we have not had that case like, released to ODR, murdered his family kind of thing. We have not had those cases. ODR has been very successful at helping identify the right people for these community programs and then having those people succeed. Now, that doesn't mean none of them ever leave the program and get rearrested, but that's also going to happen when people get released from jail. They get rearrested all the time. But what we have seen is a high level of success with ODR's programming, and it's making the right choices and getting people. As I said, there are reports done that were commissioned by the county in which they studied people who went through the ODR programs, and they have great housing retention rates. They have great not getting rearrested. And when you compare those, as I said, to the people who are just going through the jail system, the results are way, way better.
Well, we now have two. I mean, I was in court this morning on what I call my homeless millionaire client, literally. He was homeless for 6 years and severely addicted to drugs and underlying mental illness, but comes from, his father left him a trust, which he could only obviously dip into if he's well. But, he's not really a candidate for, I've had a couple of clients in ODR. We now also have mental health diversion, which is different than ODR, because I think on the maybe not housing, but on the legal side with ODR, you end up avoiding time and you still plead to the charge or some charge that you negotiate. With mental health diversion, you literally, if you're successful, you can avoid a conviction. Right. You don't have to plead to get in there. So it's really, but what I find, Jim, do you have that there? Like what you have this sort of like some programs for mentally ill clients?
No, we don't have any diversion programs.
So we do, but the problem is
drug diversion.
That's drug diversion. Yeah. We've had that for years, but the program is there and the DAs they don't agree to it. They vehemently oppose, not ODR as much. ODR has its own specific DAs assigned in the Central District, and they're pretty good. But mental health diversion, because you end up with nothing. the DAs really don't like it. They oppose it. They just are not happy that it's there. So anyway.
Sarah, can I say something about that? I mean, I think for this kind of thing to happen, for these kinds of programs to be set up, for there to be buy-in, it's a long process, because you're right. My experience dealing with prosecutors at every level, including when I was clerking for judges and watch prosecutors, and a lot of them have the "I want my pound of flesh" kind of motivation. It takes a long time, and you have to have a DA has to put in place the right people to sort of run the diversion programs, who really understand what are we getting at. We get a conviction, but this person is really sick, and they're just going to go through a system that's going to make them sicker. We're really not serving any greater good by doing that. But that is not, a lot of prosecutors don't have that mentality. And there's a real education process, but it's only when you put in place programs like ODR and you can show the successes that I think you can start to educate. You shouldn't have to do it in your community. There's now examples in different jurisdictions around the country that ideally prosecutors should be able to look at and say, you know what, that actually makes sense. The South Carolinas of the world should be looking at what's happening in some other places and saying, you know what, even if there's some people we really feel like we got to put in jail and prison, there are others that we're just wasting our time doing this. We're wasting our money, we're wasting our time, and we're creating real human carnage. Because one of the most powerful moments I had was talking to a very good forensic psychiatrist. And I was asking him, we were talking about, oh my God, the treatment of people with mental illness in the county jail in LA is just awful. It's inhumane. And I said to him, how do you change that? He said, well, just don't put them in jail. And I saw, and a light bulb went off. And then he then explained, there are these programs, these can work. But if you keep putting people through a jail system or a prison system who have mental illness, they're not going to get better. They're going to get worse. They're going to get sicker. They're going to be more likely to commit offenses in the future. And it's just a failed system.
Peter, you've got a very strong ACLU out in California, obviously. Here in South Carolina, we have horrid jail conditions. Our Department of Juvenile Justice is probably has been, one of the worst. And the Department of Justice, U.S. Department of Justice, has stepped in and essentially sued our local DJJ or state-operated DJJ. Is that something that's happening around the country? Do the federal government get involved much, or is it mostly ACLU cases that make reform happen?
Well, it's a combination, and it's not. The ACLU is not the only sort of nonprofit that does this, but they're one of the few. But there are other organizations. For example, the Prison Law Office does a lot of great work in California and the California prison system. There are other organizations around the country. You're referring, I think, pretty much to work that the Department of Justice does through its CRIPA, what they call CRIPA unit, and that's Civil Rights for Institutionalized Persons Act. There is a division within the Department of Justice that brings claims on behalf of people who are in. They can be juvenile justice, they can be jails, they can be prisons, they can even be mental health hospitals, basically people who are in conditions of confinement. But their resources are limited. They can't be everywhere around the country, but they do this work. And, I think in some cases, just sort of the quality of the work varies, but that's typical depending on who the lawyers are, how aggressive they are. But they're certainly, DOJ has brought some very important and good CRIPA cases. And in fact, in LA, DOJ has a case on behalf of people with mental illness in the county jails. So we have cases, they have a case. In some cases, we do cooperate with them and sort of, because there's a lot of interaction between their cases and our cases.
And then there's, I guess, 1983, a federal statute that provides for private lawyers can sue on behalf of inmates and for other civil rights violations. And I was involved in a class action in South Carolina involving the treatment of Hep C, which is treatable now, but it's very expensive to cure hepatitis C, and a lot of inmates have hepatitis C, and the state Department of Corrections is not providing Harvoni is the name drug, which is like $38,000 treatment program, and so we spent years litigating that. We got a settlement. We had cooperation, but and I wasn't in it for the money, and the other lawyers were not in it for the money. And it's a good thing because there wasn't much money in there to go to the private lawyers, and there's a cap on how much private lawyers can make under the Prison Reform Litigation Act. And there really was a disincentive to, for private litigants and inmates to sue on their own behalf, the way the system is set up today. At least that was my view. I don't know what you think of it. But.
Oh, no, I think you're exactly right. I think there are a lot of disincentives that Congress has created and the courts, frankly, have created to make it very difficult to bring these cases. One of them you're talking about is the cap on, so as ordinary in many typical civil rights cases, if you win the case, the government has to pay. You're suing the government, or the plaintiff is suing the government. The plaintiff's lawyer gets his or her fees reimbursed from the government at what they call market rates. But the Prison Litigation Reform Act caps the rates that attorneys can get for bringing these cases on behalf of people in jails and prisons. So that is a disincentive. We all have to make a living. And if your rate is capped way below the market rate, you may say, well, why am I going to take that case instead of the case where I can get market rate for my fees if I prevail? That's just one of the disincentives. There are others. And the reality is also a lot of what happens in jails and prisons is behind bars. Literally, it's out of view. Mm-hmm. It's harder to have video and the other things that would support a case that would make it easier for you to win a case. And then the last thing is, I think, unfortunately, there is an attitude like, well, they're prisoners, so who cares what happens to them? And so I think a lot of people who might bring a civil rights case think, boy, that client, it's going to be harder to persuade a jury to be sympathetic to that client, even if his or her rights were grossly violated. So that you're right, Jim, there's tons of disincentives to bringing this as a case. I have the luxury of working for a nonprofit. I ain't making a fortune,
right?
But my organization is paying me, and they're yes, it's nice when we win cases and get attorney's fees, but they're not saying you can only, if you can't get attorney's fees in a case, or you can't bring the cases where they're capped attorney's fees because we won't support that. They will support it. And so I'm able to do that. But the private bar, it's much harder for them to make that decision to do it.
Every settlement, you don't get everything you want in a settlement. So, is there something more that the ACLU wanted to see out of this, or are you pretty satisfied with the terms and conditions that they're to comply with?
I mean, honestly, you're exactly right, Sarah. No, I'd love to meet the lawyer who wins their cases and says, I got everything I want, or at least settled and gets everything they want. Actually do think it's quite a good settlement, but ultimately the more the pieces where we have more enforcement capacity are about what happens in the IRC. But ultimately, if this problem is going to be solved in the long term, the county's going to have to build these community beds to reduce the population of mental illness. That's in the settlement. For complicated reasons, it's not as easy for us to enforce.
Yeah.
But if the county does that, then I would say this is, about an A settlement. It's not an A plus, but it's an A settlement. If the county abides by its terms, I'll be very happy.
Here's a question I'd like to ask. What can somebody like myself that's like upset hearing about all these things you guys are talking about? Like, what can we do? Do we have to just vote different people in power? Like, all I'm hearing.
Donate to the ACLU.
That's it?
ACLU.org, click donate. I was going to say that at the end, but hey.
Thanks, Sarah. I appreciate that. Yeah, great question, Matt. And yes, you can support organizations that do the work that you believe in, bring these cases. But I think some of the part of the reason the county set up the Office of Diversion and Reentry was, I think there were some people who realized it was good policy, but they did it under political pressure. And political pressure does come from the people. Now, it can be very frustrating. You can write a letter to in our case, the Board of Supervisors, you can write a letter to because they run the county. And so they are going to make decisions about certain criminal justice issues in the county, much more than the city. And you can write to them. Now, they're not always going to listen. Oftentimes they don't listen, but the reality is they do have to worry about what their constituents think. But if their constituents aren't banging down the door and saying, we actually care about these issues in the criminal legal system. And we think it's a disaster for you to be sending all these people with mental illness to jail. And you should be looking at what some of these other jurisdictions have done and have developed these community systems. Eventually, you may make some headway. But if they're not hearing from you, there are plenty of constituencies for law and order and for the cops and so on. But if they're the people who are also coming and weighing in on the other side and saying, this ain't working, the cops are saying, just throw them in jail. But frankly, honestly, Matt, a lot of times the cops say, we don't actually want to throw people with mental illness in jail. Just don't know what else. We don't have any alternative. But I've had some really very good conversations with law enforcement saying, oh, yeah, it's crazy how many people with mental illness are in the jail. And we don't do a good job of handling them because we're not clinicians. We're cops. And they're happy to have people with mental illness diverted out of the jail system. Mm-hmm. But then the powers that be have to create those community beds. And pressure from members of the community can matter. Not always easy, but I think that's another way that you can be involved.
That's the hardest thing to advocate for in a state like South Carolina is prisoner rights. I mean, it's easy to, and what gets traction is mandatory minimums and, and more crimes and, longer sentences. But then they don't have a way to pay for them. Peter, I'm sort of going in the cobwebs of my memory about, it seems like in the Reagan administration is when they started closing a lot of the mental health facilities and putting people who with mental health issues on the street. And then I guess, now what we're seeing 30 years later, they're all migrating and been spending time in prison instead of in mental health facilities. Am I off?
No, I mean, it's slightly oversimplified, but basically accurate. But the reality was the sort of closure of the mental hospitals was supposed to be accompanied by the funding of community treatment. Because I don't want to be too nostalgic about the mental hospitals. They were pretty awful.
Yeah.
Right? Better than jail and prison, but pretty awful. But you talk to any good mental health professional, and I tell you that keep having somebody with mental illness connected to the community in community treatment with appropriate supports and services, that's far and the best thing for them and the best thing for the community generally. Mm-hmm. But you have to fund the community part of it. Just closing the mental health hospitals is not a solution, and it clearly wasn't a solution. We just haven't funded the community system. So what we end up doing instead is funding a mental health care system for poor people in jail, which is a disaster. It's expensive and it doesn't work.
Yeah, exactly.
A lot of people, this is really for our viewers, use the term prison and jail interchangeably. They're not the same thing at all. Just for everyone out there who doesn't know that, prisons are where people who have been sentenced for felony crimes go to spend many years, sometimes the rest of their lives. And functionally, the fundamental difference between prison and jail is the access to jobs, education, programming, therapy, recreation, etc. In California, the law several years ago, we refer to as 1170, passed where certain lower level felony convictions, the inmate serves time on in the county jail system, even though it's a prison sentence. Mm-hmm. I have a real problem with that. I have for past several years, but sometimes these people are in there for decades, they violate, their term gets extended, etc. What is the ACLU's position on that? I mean, that's adding to the overcrowding of jails for pretrial detainees, obviously, and the problem. So does ACLU take a position on that?
Well, here's the law that you're referring to. Basically, yeah, it says exactly that. Certain sentences that used to be served in prisons are now going to be served in jails. To me, and I hate this metaphor because it gets so overused, it's sort of rearranging deck chairs on the Titanic. The state prison system was grossly overcrowded. Even a very conservative Supreme Court affirmed a lower court decision saying you have to reduce the population because it's indisputable that you cannot provide even the basic level of medical and mental health care to people. Mm-hmm. And you cannot do it when you're it was about 150 to 160% of your rated capacity. So a facility, just using round numbers, it's supposed to hold 1,000 people, designed to hold 1,000 people. There are 1,500 people in it. And, for year after year, they would go into court and show that they could not provide adequate mental health and medical care. And I don't mean adequate like top notch. I mean,
No, like
basic level of humanity.
Basic, yeah.
So the state responded to the order that said you have to lower the prison population with this thing that said, okay, let's move some of the people who are in the prison into the jails. But many of the county jails are overcrowded too. So it wasn't a solution to anything. And you're right, Sarah, that in some ways, I don't want to go to state prison, awful. But in some ways, there are certain things set up in a state prison that are probably better than in a county jail, because a county jail has a lot of turnover, and it's very hard to set up systems of providing any kind of programming or whatever, because the population, even though there's a subset of the population that remains there for a long time, but by and large, it's a sort of a system where people churn through it. They may be in there for one night or two nights. And so it's not set up for long-term,
Right.
And so, yeah, it was not. So we didn't really oppose it or support it. It was because our basic point was, look, you have too many people in the system. Moving them from one part of the system to the other is not it doesn't really solve anything.
Mm-hmm. And do you think that Jim, so we have a new DA, fairly new DA in LA County, who's very liberal. He's a former cop in San Francisco. There's been a lot of drama about, petitioning to remove him and all of this stuff. Anyway, I supported him. I like him. But one of the major things he did was put in place these zero bail policies on nonviolent offenses. So, I had a vehicular manslaughter case that you know about, and I was able to walk in and out of the arraignment without any detention hearing. So even if it's a felony, if it's nonviolent, the DA's office is not supposed to be seeking bond. I'm wondering, Peter, if that has helped, the overcrowding problem, since a lot of people are not, are just bail, basically not having to post bail.
So the answer is yes. But it was also combined with the fact that the state judicial system pretty much put in zero bail for a lot of charges in COVID, but then they then revoked it. So that's been a problem and pushed the population up somewhat. But yes, individual DAs, including DA Guest, going through these policies helps reduce. That is a component of reducing the population. But, your question really raises, I think, another fundamental issue, because I think there's a huge misunderstanding about bail. Again, bail is often thrown around as a way to keep the community safe. But all the evidence is that people go. So first of all, people who defend their cases while they're out on bail or otherwise not in prison, in jail, are more likely to have the charges against them dismissed, more likely to be found by juries if they do go to trial, found not guilty by juries. It's much harder to work with a lawyer from jail. Yes. You also, frankly, the number of people who plead guilty to cases, the way DAs stack it, it's such that basically people will say, I'll plead guilty because I can get out right away. But if I go to trial, even though I know I'm innocent, I'm going to spend more time in jail. So why am I going to do that? But then the collateral consequences of having a conviction oftentimes ruins people's lives. But the other thing that's really important is there's really good research now that shows that a lot of times people will get booked and they can't afford to post bail. They'll spend a night or two nights in jail and then oftentimes DAs will dismiss. They'll say, there's no case here. I'm not charging on this. But those 2 nights can be the difference between people losing housing, losing their job. And frankly, people who lose jobs because of this are more likely to commit crimes in the future because they're not employed and they don't have a source of money. Bail actually drives higher crime rates. It doesn't keep the community safe. It actually does the opposite. But unfortunately, bail bondsmen and others have done a great job of saying, these, when you change the bail system, it's, it creates all this crime. It's the exact opposite. Right. And the evidence shows that, but unfortunately the media and the megaphones that support the bail system have actually been much more effective at getting their message out.
So if Jim and I go to court, and can we cite to your great work in Rosas versus Baca and say, this is cruel and unusual punishment, so our client needs to get out?
Well, Sarah, I mean, I can't speak to you. Well, Jim can't because he can't point. He's not his client.
I know,
but you maybe. But frankly, I'm aware there was a judge. I'm aware of a specific judge on a court. I'm not going to mention a name, but the specific judge who read about our lawsuit and said, I'm looking at the papers, and when DAs come to me and say we have to, no bail or whatever, I am going to at least raise the question: is this the right place for them to be pending, while their proceedings are worked out? Because this seems to me there are very serious questions about whether anybody should be put in this condition. I don't know if you
judge in Long Beach.
I'm not.
Daniel Lowenthal? No,
I'm not saying.
Okay. Well, I know somebody showed up. I have to find the article for you, Jim. He comes from a very, very, very liberal family. I think his father was a representative in the House, and I think his brother's running for office. Anyway, he doesn't care. I mean, it's really shocking to see for a county court judge. But he came in one day, and I think he declared a mistrial or something because the defendant had not been able to sleep for a few days in county jail. And he said, well, this guy can't participate in his defense. So, and it was just like, it raised all this outrage. Do you remember this, Peter? Maybe I'm not.
No, I do. And it was because of what was happening in the IRC. This person was spending nights in the IRC, sleeping on or trying to sleep on a cold concrete floor. And the judge said he can't, it was a serious charge. And the judge said, I'm not allowing somebody who's trying to defend himself against a very serious charge and is staying in these hellhole conditions and can't sleep I'm not allowing him to be tried. I thought it was a great decision.
Yeah.
Peter, and here in South Carolina, when we have a client who's facing potential state jail time, federal jail time, we'll do anything possible to get them in federal custody over state custody because it's just night and day difference between our state system. And I'm just wondering what your perspective is across the country. Are the federal prisons run that much better than state prisons, or is this a South Carolina issue?
So I need to plead a large bit of ignorance. I haven't done much with the federal system. I'm not that aware of how it runs overall, and talking to other people who have done more jail and prison litigation around the country, my instinct is slightly better, but not great. But that could also vary a lot in a particular jurisdiction. It may very well be that in South Carolina, it's dramatically different. In other places, I'm not so sure.
Sure.
But my instinct is probably a little less crowded, probably a little better on average than a lot of state and county systems.
Right. It is. We have overcrowding, major overcrowding problems in the state system here. Although it's getting better, we're having, more people are being released than incarcerated for the last 5 years, which is really surprising for a state like South Carolina. I think it's a budget issue. I think they've realized that it's cost so much to house an inmate, and they're trying to find alternatives to that. But hopefully that's a trend that'll keep on. We'll see.
I have one final question. If you could redo the American jail system, what would it look like?
It would be so much smaller. That would be the number one thing. It would just be so much smaller. We wouldn't have a bail system. We would have individualized determinations of whether there really is a very good and very strong reason to hold somebody pretrial. We would have almost nobody with mental illness in the system. It is, and again, I just want to keep coming back to this because I think it's important to look at. There's so many people who feel like they have to oppose my point of view because they believe in public safety and I don't. But that's not the case. I mean, again, I can happy to provide people with reports in which they've studied the people who've gone through these community-based mental health treatment programs compared to similarly situated people who are going through the jail system. Mm-hmm. And we are so much safer as a result of these community programs, because people are retaining housing, they're getting mental health treatment, they are not getting rearrested or not nearly at the same rates as the people who are going through this barbaric system of being pushed through the jails. So you can have the public safety, more humane treatment, and spend less money with a much, much smaller jail system.
And we certainly incarcerate more people in the United States than, I believe, any other country in the world. Is that accurate?
Mm-hmm.
I'm not sure it's every country, Jim, but basically every country that we think we're similar to, sort of.
Right.
Comparable countries.
Yeah,
comparable countries.
Yeah.
All right. To all our listeners and viewers, please consider donating to the ACLU. It's a wonderful organization of justice warriors led by people like Peter, who fight for our civil rights and our constitutional rights. And you can go to aclu.org and click on donate. And I'm sure, as with any charitable organization, every dollar counts. And Peter, thank you so much I know you're so busy. And I hunted you down in a gym, of all places. We work out with the same guy. And you took my invitation to join Jim and I and Matt. So I really appreciate you. This is a very important issue, obviously, across America. And hopefully we'll do more segments on jails and all the good stuff that you're working on. I'll be keeping a close eye out for your work.
Well,
thank
you for having me. And thank you for bringing, and part of my work is actually getting out and talking about what we do, but also trying to educate and explain what we do and why, and the horrors of much of what happens in jails and prisons and why it's not good for the community generally. So I appreciate your willingness to tackle this topic and have me on. Yeah, we appreciate you. And until next week, Jim, shall we rest?
We rest.